Hey guys, if we've learned anything in the Darrell Brooks trial, besides the fact that the jury did the right thing in convicting this guy for the murders, he was responsible for the injuries he was responsible for, despite the fact that he doesn't want to be responsible for anything, is the importance of grounds in a trial. You can never have too many grounds in a trial. What we'll look at here is, did he develop grounds for appeal? He pulled a lot of antics before the trial started with his sovereign citizen nonsense, switching over to self-representation.
So you're going to have to tell me what you think that means.
It is me exercising my right to defend myself, to represent myself as a sovereign citizen.
Do you wish to represent yourself in this case?
Yes, I do.
All the crap he said during the trial about subject matter jurisdiction, fringe on the flag, an eagle on the flagpole. Sorry, stupid. And the way he behaved, and there was some concern from some people that he's trying to show that he's crazy, so he could get off for being crazy. Also that maybe he shouldn't have been allowed to represent himself, and so he could get a new trial for that. So let's take a look at that and see whether he has grounds for appeal or not. First of all, let's just start with the not guilty by reason of insanity plea. He did enter that early in the case, but he voluntarily withdrew it himself while he was represented by his attorneys. He did that himself, and the judge went through the whole thing about this is what you want to do and you're not pressured to do it and that sort of thing. Let's take a look.
I'd like to discuss with you your decision to withdraw the special plea of not guilty by reason of mental disease or defect. Is that your desire, sir?
Yeah.
And have you had the opportunity to thoroughly discuss your decision to withdraw your special plea with your attorneys? Have they discussed the advantages and disadvantages of withdrawing that plea with you?
I have my own reasons why.
All right. And has anyone made any threats or forced you in any way to withdraw your special plea of not guilty by reason of mental disease or defect?
No.
So no, he's not going to get off because he was crazy during the crime itself. So remember, being crazy during the crime is one thing. You can have not guilty by reason of mental defect or not guilty by reason of insanity kind of a thing. There's also the notion of being crazy during the trial. And in case you're crazy during the trial and you can't understand what's going on and you're bonkers and all that, then they're not supposed to try you during that time period. So your craziness can cover all of that, of course, but it may just only cover part of that. So he withdrew his plea of being bananas during the acts themselves. Remember, just being crazy is not the legal definition of insanity or mental defect. To get off for a crime, you have to lack the capacity to know right from wrong or to control your actions. He wasn't going to meet that. There's lots of videos of him doing things and running away from the scene, which itself indicates an awareness that it was wrong. So it wasn't going to succeed. But whether or not it would have succeeded, it would have changed the dynamics of the trial because procedure is a little different when there's an insanity plea involved. But he withdrew it himself, and we looked at that. So that one's out. So all the antics at trial, things like that, they're not about the insanity plea. They are, I think, about some other things. And one of them is Brooks has gotten away with a lot of things in his life that he shouldn't have. He's gamed the system. He's committed many felonies, hurt many people, yet he was always back out on the street eventually, a lot of times immediately, to do it again. He used his mother's SUV in a rap video. That should be a serious felony. He was never charged for that, so that's unfortunate. And finally, one day, he did what is not too surprising, I suppose, for somebody who has no empathy, no sympathy, no ability to care about anyone else. He drove down the road trying to do whatever he was going to do and get away from the scene that he'd previously been harming someone, and drove over innocent people and killing and maiming many people. And of course, that's what this trial was for, and he was found guilty. So now he's facing sentencing and, of course, an appeal. So first of all, can he appeal? Yes, he can appeal. He can file a notice of appeal. And it's an appeal of right when you're convicted of a crime. He has the right to appeal. He doesn't have the right to a successful appeal. He can ask the state to appoint a lawyer for him to help or to do this appeal, or hopefully he will continue his stellar legal performance and career and do it himself, which he also can do. And so after he files the notice of intent, then he can file a notice of appeal, and he can armor it upward to tell the higher court why his rights were violated and why the lower court made mistakes and why I'm sure in his mind he should just get off scot-free, but in the absence of that, he should get a new trial where he can try and do all this again. What did he do to try and make the magic happen that could allow him to do that? And did he outwit this judge? A spoiler alert, of course, he didn't do that. He didn't succeed in that. He just, I think, really did think that he could. So just before the trial started, of course, he fired his own lawyers. And that created a tough situation for the judge because it was shortly before trial. And there are a lot of things at stake there and things that the judge has to do to ensure that the situation is fair. So first of all, you have to be competent for trial. Okay, you got to be able to understand what's going on. In some ways, assist in your own defense. You're not imagining you're on another planet or in an underwater fantasy land or something like that. It's not a high standard, right? You don't have to be Clarence Darrell here. Okay, you just have to basically know what's going on. The idea being that you can't put somebody on trial and have them defend themselves if they're not aware even of where they're at or what's happening. That he's nowhere close to meeting that standard. But that would be the first one, okay? Then he, shortly before trial, invoked the next level of concern, which is he wants to waive counsel. Under the Sixth Amendment, he has a right to have an attorney defend him. And if he can't afford one, of course, they appointed one, or more than one in this case, and he decided at the last minute he could do it better himself. So that engages a process the judge has to go through because you do have also a right not only to have an attorney for a criminal charge, but the right to represent yourself. That's a constitutional right. The Supreme Court has been very clear on that. The government cannot force you, if you're a sane person and you meet the minimal requirements they have, to take a lawyer from the government. You can do it yourself. Is that smart? It depends on the situation. But your constitutional rights don't depend on you being smart or smarter than the government thinks you should be. So he says, I want to waive counsel. So that means that the judge has to go through a series of things to make sure that his waiver of counsel is voluntary and knowing. So she's got to develop a record and have him sign a form that says he makes a deliberate choice to proceed without counsel, that he understands the natures of the charges around him. She's supposed to look at some factors that the court wants her to look at to make sure this guy's mentally there enough to have an understanding of what going without a lawyer means. So she has to make sure he understands the process, which charges are, the potential penalties, and then the ups and downs of not having a lawyer. You're giving up the experience. You may not understand what's going on around you legally. And it's critically important here, in case people think otherwise, the judge is not there to test whether the person understands the law or legal principles or is going to know every defense or everything they should do. That's not a requirement to exercise your constitutional right. All it is required is that you understand you may not know those things and you're deciding to do it anyway, which is what he did. So let's look at a little bit of that.
Anyone make any threats or force you in any way to waive your right to an attorney?
No.
Anyone make any promises to you in exchange for you waiving your right to an attorney?
No.
You understand, sir, that means attorneys Keys and Attorney Perry will be discharged from this case.
Yes.
You are aware that means they will be discharged from representing you.
Yes.
You are aware they will not join you at that table after that decision is made.
I am informed, yes.
Do you believe you are making the decision to represent yourself knowingly and voluntarily?
Yes.
Do you believe you are fully informed about the advantages of having an attorney, someone licensed to practice law in the state of Wisconsin, represent you?
Fully informed, yes.
Do you believe you are fully informed of the disadvantages and challenges of representing yourself and acting as your own attorney?
Yes, I am informed.
So for the waiver, if you make a deliberate choice to proceed by yourself, you're aware of the difficulties and disadvantages of not having a lawyer, what the advantages of having a lawyer are. You know what the charges are and the penalties. You can sign this waiver, and they're going to ask you, were you coerced, voluntary, all those sorts of things. And she makes sure that you're mentally there enough to know what's going on. Now, he tried to game that a little bit by changing the form and marking out understand with I am informed. And to him, that's extremely clever because one of the core elements of a successful waiver is understanding. If you don't understand something, then you can't waive it. That's basic. Did he get one over on the judge? He did not. Through her development of the conversation with him and the rest of the things that he did, it's pretty clear that he understood what was going on, and his attempt to change the words was simply to try and game it. I did do a little bit of reading in Wisconsin for their higher court rulings on serious defendants who have tried to game the system. In some cases, not even saying they didn't want a lawyer, just firing series of lawyers and finally being found to have waived their right to one because of their conduct. It's not a court up there that appears to sit around thinking up imaginary ways to let dangerous people back out on the street. So if you've got a real violation of rights, yeah, go to the court. But if you're trying to game it, I changed this word from understanding to I am informed, and then I had a full conversation on videotape with the judge that shows that I know exactly what she's talking about, but I just want to say I don't understand it, it's not going to get you anywhere. So nice try, Darrell Brooks, for avoiding responsibility for your crimes by changing a word on a form, but it's not going to work out. So he waives his right to counsel, and one of his first brilliant defenses is, I'm not understanding, I'm just informed, and that's not going to work. So the court also has to make sure that not only is your waiver knowing and voluntary and meets the minimum requirements for that, but in Wisconsin, there's an additional test that you have to show that you are competent to self-represent. So they call it a higher standard for determining whether a defendant is competent to represent oneself, and that's higher than determining competency for standing trial. So then they're going to look at, are you literate? Do you know English, the language being used in the courtroom? Do you seem to understand what's going on? You're able to go back and forth with the judge. And he could do all those things, and the judge was very careful about noting that. Now, what it is not, however, is a bar exam. You're not passing the bar here. You're not becoming a lawyer. The judge should not sit there and go, tell me what Rule 403 is, or how do peremptory strikes on a jury work? What are the 13 exceptions to hearsay? That's not what happens. If you don't know those things, that's not actually relevant to determining whether you're competent to self-represent. All that is whether you have the mental capacity to talk your game that you want to talk, if that's how you choose to do it. You've already been apprised of the dangers of rolling your own. So that's what goes on there. So he doesn't have a leg to stand on there on the competency issue because, look, whatever else is funny about how this guy represented himself, and a lot of it was ridiculous, he knew what was going on, right? He was playing the game he wanted to play, all the sovereign nonsense, badgering witnesses, using objection words like crazy. He knew the game. Was he as skilled as the prosecution in legal tactics? No, obviously not, but that's not the test. So he was good enough to represent himself, and the judge made a fine record for that. And that leaves him with his last tactic on this angle, which is standby counsel, because he did say to the judge that I do not want to waive my right to assistance of counsel. I just don't want these lawyers doing it. I want to represent myself, but I'm not waiving a right to assistance of counsel. And he wanted standby counsel. So is he right there? And a fair point that he makes there, that if you're telling me that I don't understand certain legal tactics, and under the Sixth Amendment, it guarantees me the right of assistance of counsel, well, then provide a counsel to assist me in the things that I don't understand and let me represent myself. Why does it have to be all or nothing? Well, that's how they read the amendment. It's all or nothing. There's not a constitutional right to stand by counsel. There is a constitutional right, as it's interpreted by the Supreme Court, to counsel, but not to stand by counsel. And the judge was extremely clear on this. This was not a mystery to him. Although he thought he deserved to stand by counsel, she told him, if you fire your lawyers and represent yourself, you will not have standby counsel.
Why did you not check this box?
Because it is my understanding that representing myself pro per, I can have standby counsel. So that, in a sense, is why that box specifically is not checked.
That is not a correct statement of the law, sir. Standby counsel is not for the benefit of a defendant, it's for the benefit of the court. This court would also not appoint standby counsel in this case. Did you hear me say that?
That's fine.
Nevertheless, after that, he told her, yes, I do want to discharge these counsel and represent myself. So some people will say, well, they don't have standby counsel in Wisconsin, and that's incorrect. They do have it. When the judge wants to appoint a standby counsel, the judge can do that, and the judges have done it in various cases. In fact, there have been defendants who complained they didn't want standby counsel, and the judge appointed that person anyway. But the test is that the judge does it for the benefit of the trial court, not for the defendant. So in other words, if the judge decides, well, this will help make this more orderly because this person's an idiot, and if I have a lawyer over there, maybe at some point that lawyer will be able to explain to this idiot why something is happening, that'll help me get through this trial better. That's what the judge can do. It's not a standby counsel that is requested by the defendant for the benefit of the defendant. It's simply one that the court can do in its inherent power to move the proceedings along in an orderly fashion. So there is such a thing as standby counsel in Wisconsin, but there is not such a thing as a defendant's right to it. And the judge was extremely clear when she told him there's not going to be any appointment of standby counsel in this case. We're on the eve of trial. And she thought that he was doing it to delay things, which I certainly think is true. And he didn't succeed in that. I think his mom said in an interview that, he's thinking he's going to get this delayed. And in fact, his mom wrote, I think, an 8-page letter to the judge saying, please, judge, do not let him represent himself. He's mentally ill. He doesn't really know what's going on. He shouldn't be doing this. Those are all fair points. Okay. I'm not saying his mom's wrong. I feel sorry for his mom, but all he has to do is meet the minimum requirements. Remember, it's as much a constitutional right for him to not have a lawyer as it is for him to have a lawyer. So you can't just easily deprive him of that if he meets the minimum test. So I think he has failed on his not understanding, but his informed grounds. He's failed on he doesn't want to waive his right to counsel. He wants to have a Burger King where he has it his way. He wants a lawyer to do what he wants to do because he thinks that's his right. That's a fail. So there's no grounds, successful grounds there. The grounds of there being an eagle on the flagpole, not going to work. Grounds for there being fringe on the flagpole, not going to work. Grounds for saying that his name is not what his name has always been and what he always answered to, not going to work. Grounds as a third-party intervener, it's not going to work. Subject matter jurisdiction, it's not going to work. None of the sovereign citizen nonsense is going to work. There are a lot of dumb people who think it's true. I don't know that he thought it was or not, but he definitely wanted to game the system with it. It's all a big fail. Now, there were later things in the trial, his objections here and there. That'll all be part of an appeal too. And more seriously, his waiver of right to testify and things like that. But I think the judge covered those things as well. What I want to do in this video was look at the antics that he started, which was when I really started to watch this trial, when he decided to be self-represented and decided to really try to, in a maximum way, game the system, whether he was going to succeed in any of that or not. And some of that depends on who the judges square off with. Is that judge going to be good or not? And this judge was very good about ensuring he had a fair trial, okay, because he clearly did it, but she made sure that he had his chance to present whatever defense he wanted to present. And secondly, not to give this nut some kind of artificial grounds for appeal. That didn't happen. In my opinion, she covered that extremely well in fairness and in procedure. And now it's just going to be down to the hearing where I suspect that she will easily make the finding that his life sentences will be without parole and without extended supervision, and he'll go to jail for the rest of his life. That's the best outcome for him. And I feel sorry for his mother, but at least her child is still alive, and that's more than you can say for the people that interacted with Darrell Brooks that sad day. Well, we'll see what happens at the sentencing hearing. Thanks. Bye.